Well, hello, everybody. It is now another edition of Zoom Landlord-Tenant Talk Radio, a special Thanksgiving edition. Appreciate everybody who's come out to join our meeting today. And hopefully we will have a lot of questions. Some of the ground rules that I always talk about is that this is for informational purposes only. It is not a substitute for legal advice. If you do need help, please seek the services of an attorney. I'm going to make sure that if you want to be called on, please electronically raise your hand. There's a button on the bottom of the screen, and you'll be able to let me know that you want to talk. Please keep yourself muted unless I ask you to join. And if I do, then please join, ask your questions. Please try to keep them succinct so we can get in everybody who wants to talk today. Again, if you have a specific case with me, please do not discuss that specific case. That's most available for you to call the office, and we're happy to have myself or one of my other attorneys let you know that we're about your case and what's going on with it. This is for general questions only. I don't want to get bogged down into specifics for an individual's case. I do want to start off today with an unusual topic. I had a client call me. This is a couple of days ago, and incredulously, she said she was getting fined by the city. She was getting fined a total of $350. I have the actual administrative violation and fine due paperwork in my hand. She's getting fined it's a total of $350, basically $116 per item. There's 3 items on here. First item is that she needs to get a dog license. And the second item is something called failure to exhibit receipt certification. I guess that you didn't display your dog license. And the last thing is failure to spay or neuter your dog or cat. So she was faced with this. And here's the crazy part. She doesn't own a dog. She doesn't own a cat. She doesn't own any pets. What the fine was about was that one of her tenants doesn't have their cat with a license or spay or neutered. And instead of fining the tenant, I know we live in an upside down world, honestly, but instead of fining the tenant, they're fining the landlord. And she's been trying to call the city and finally, and getting nowhere. She doesn't own a cat or a dog. She can't get it spayed or neutered. So anyway, so she enlisted my support. But we see this example and this is, of course, the city of Los Angeles. What else? But we see this example when landlords rent commercial stores to somebody, and what are you going to be selling? Oh, I'm just going to be selling, food items or whatever. And then, of course, as soon as the guy gets into the store, he starts selling marijuana without a license. So you would think that the police would come over and arrest him. I mean, that's a chargeable criminal offense. But that's not what the city does. In the city of Los Angeles, they file criminal charges against the owner of the property. And they give the owner of the property, hey, you better get rid of this tenant, otherwise we're holding you criminally responsible. Well, I don't know, call me silly, but should this be on the basis that the tenant is the one who's prosecuted? Or in this case, isn't the tenant who doesn't have the dog license, shouldn't that be the one? But of course, again, we all live in an upside down world. So that's my story today. we're gonna try to do something with the client, and next Saturday I'll give you a result if I have one on that. But we are going to open it up to questions at this point in time. So again, only unmute yourself if I ask you to, and we're gonna go first with Dina. She's our regular, we love her. I'm gonna ask you to unmute yourself right now if you can.
Hi, Dennis. How you doing? Many thanks. Always many thanks for your support for landlords. It's really appreciated. And my question actually consists of two questions on the same subject. And I would like to see your thoughts regarding a follow-up on a question I had about the mitigation of landlord upon the break of the lease by the tenant, which my understanding mitigation is reasonable effort. So to do that, so I mean, having the market or putting the market over, putting the property over the market rate would be unreasonable. And the market rate would be the status of equilibrium between demand and supply. So then that would be reasonable. So and then why does the landlord has to be deprived of having, you know, the market rate when the tenant breaks the lease? And I want to ask, what should we argue in this case if we put the property there? And the other question also, when the tenant will vacate the unit and I prepare the security deposit, which I like very much. Thank you so much.
Dina, let me slow you down.
Yeah,
one question at a time, because otherwise I think people lose interest. What Dina's talking about is that she has a tenant who is early terminating the lease. So in other words, let's pretend the lease goes to May of 2024 and the tenant says, hey, I'm gone. So under the law, the tenant is responsible, whether they're there or not, to be responsible for the rent to the end of the lease term. However, the landlord is also responsible for using the landlord's best efforts to mitigate the tenant's losses. So what do I mean by that? In other words, that the landlord has to attempt to rent out the unit. And by renting out the unit, then the tenants who's vacated, their losses stop. So let's pretend that the landlord gets the unit rented out in January. Then at that point, the tenant would only be liable for the November and December's rent. What Dean is talking about is that she wants to use her best efforts to rent it out, but she wants to go above what the other tenant was saying. So this is not a matter of debate, Dina. This is the law, and it's well settled that if you do try to rent it out at a higher rate, then that's not by law considered to be using your best efforts. And therefore, at that point in time, the tenant has no further responsibility under that lease. So it's not something that we can debate. It's just what the law is. Let's move on. Let's move on to your second question.
Okay, my second question, thank you so much. One comment, very short. But isn't it sometimes, Dennis, because it is a market rate and the status and what the market is asking for, so it shouldn't take that long maybe, or longer than when the rent goes down? Would that be a fact considered or no?
Well, you could ask it 1,000 different ways, but the reality is I'm sticking to my guns because that's what the law says.
Okay, very quickly, the second one, regarding the security deposit, and by the way, you have an awesome one on your website I'm going to use, but should I, after 21 days, when they vacate the unit, should I return everything to them if they didn't do anything, or charge them, or I should keep some in case they don't pay the rent? What should I do in that case?
I don't think I'm following that. If security deposit is only after they vacate the unit.
Yes, after they vacate 21 days. But let's assume that I use some of it, or 120, whatever, and then I would return for them the rest at 21 days after the vacation of the unit. Then in this case, should I keep some till they really or till I rent the unit in case they don't pay rent, or no?
You should keep. Okay, so in your situation where the guy is early terminating, yes, on your security deposit itemization, and then we're going to move on to another caller or person on our meeting. you have to deduct for the full term of the lease. So if they owe you 5 more months, I'm going to say the security deposit is 1,000 and you owe 5 months at 1,000, so that's 5,000. So you still owe me 4,000. But at that point, I would put on the security deposit itemization that I'm going to use my best efforts to re-rent the premises. If it is re-rented in this term, then you'll get your money back. Okay, well, thank you very much,
Thank
Dina.
you. Thank you so
if you
much.
could mute yourself, I'd
Sure.
appreciate that. We're now going to go on to our good friend, Kurt Freeman. I'm asking you to unmute if you'll be so kind.
Yes, thank you, Dennis. I attended one of your previous meetings and I appreciate your time and effort in doing these. I really love your Zoom meetings. I'll get on to my question. I have a tenant in one of my RSO units, rental, LA rent control, been there 27 years, long before I owned the building. And I'm going to submit to him, I like your change of tenancy regarding your insurance paper, your insurance change of tenancy, which I see you had online. I love it. My question is, has your firm had experience with this new form holding up in court? Because I'm so worried that our liberal judges are going to take the side of the tenant and say, oh, I'm so sorry, Mr. Landlord, it wasn't in your lease that you wouldn't cover their losses, so therefore you can't change their lease. So I'm just wondering if you would speak to that, if you have experience that, if this is held up.
This has held up. It's not, we're just changing the terms. Anytime you have a month-to-month tenancy as opposed to a fixed term lease, the landlord is allowed to change the terms of the tenancy by serving a 30-day notice. So
Okay.
For the other listeners, what we're talking about is that let's pretend you have a flood in a unit through no fault of the tenant. The tenant has no fault whatsoever. It's just a pipe burst. And let's pretend that his Persian rug, which is always at least $10,000. I don't know why all Persian rugs are $10,000 when they get damaged. So he's looking to you for compensation. So if you have a provision in your rental agreement that states that the tenant shall or must get renter's insurance, which will cover all of his losses for his personal property. And if in fact you are damaged, that would be the sole way of being compensated. That could either be in your lease or you can serve a 30-day notice to change the terms of the tenancy to include that tenant shall or must get insurance to cover their losses. And this will be the only sole way that the tenant would be compensated. This has been held up and it's just a good way of avoiding these types of lawsuits. So I don't have any problem with that. I think you need to unmute yourself, my friend.
Okay.
I'll try it again.
Unmute. Okay, I'm sorry. My follow-up question regarding the same form, Dennis, is that it does say that if it's a rent control unit, you should say may maintain. You can't say must maintain, correct?
That is true. But what you're trying to do is you're not forcing him to pay money for an insurance policy, which might violate some rent control issue. But what you're trying to do is avoid the liability if you get served.
Right.
That's what that is. All right, Kurt, thank you for the question. And I'm going to move on now to Audrey Smith. I'm going to ask you if you'd be so kind as to unmute yourself. Audrey, got to click on that little button.
Yeah, okay. Okay, thank you so much. I really appreciate these sessions. So my question is about serving, well, once you serve a 3-day notice, I say for $2,500, and then on the 3rd day, the tenant pays $700. What options do I have? Do I take the $700 and reserve her again, or do I not take it, or what?
What city, please?
LA.
Okay, and so LA has this crazy rule called the threshold rule. How many bedrooms?
1 bedroom.
Okay, so, and the rent's $2,100, correct?
No, the 3-day notice was about $2,500. She's missed like 2.5 months.
Okay, well, you can certainly, here's the rule. For a 1-bedroom apartment, you can't serve a 3-day notice if the 3-day notice is has to be above $1,747. $1,747. If it is, then you can serve it. So a lot of times, let's pretend your rent's $2,100 and the tenant gives you a partial payment of $700. That means for the month of November, only $1,400 is owed, which means you can't serve a 3-day notice. So if you're going to be below the threshold, I wouldn't take a partial payment. And for the record, a landlord does not have to accept a partial payment of rent. There is no requirement that they take a partial, the full rent or nothing. But if you're going, even with taking that partial payment, you're still going to be above the threshold, then there's no reason not to take it and to serve a 3-day notice for the balance that's owed. So certainly if they owe 2 months rent and the guy's going to give you $700, well, you're still going to be above the threshold. The threshold, ladies and gentlemen, is that it has to be above $1,747 for a 1-bedroom apartment, $2,222 for a 2-bedroom, $2,888 for a 3-bedroom. And the sick part is I don't even have to look at my notes to remember that because we deal with it every day. Anyway, thank you, Audrey. Appreciate that. Yeah. I'm going to mute you and let's move on to Teddy. Teddy, why don't you unmute yourself?
Hi, Dennis. Thank you for this format. Appreciate it. I've got a 6-unit in West Hollywood. It's had fire damage and water damage, and it's been vacant for 7 or 8 years now. And half of the tenants, everybody's gone, it's vacant. Half the tenants are gone, not going to come back. The other tenants have decided in mass, 3 of them, that they want to come back, and they want to come back at the original rent from 8 years ago. Is that, do we have to go along with that?
Well, before we get to that question, what's the name of your contractor? Because I'm sure his name is Snail, right? 8 years to get your property back?
It's my uncle's, and he's got a lot of issues, and mainly him. He's more the snail than is the contractor.
Sure, blame it on your uncle. You know,
yeah,
that's what I always do. Something goes wrong, it's my uncle's fault. So
yeah, if it was mine, I couldn't afford to hang on to it 7 years. I'll tell you that.
I am not sure what the rules are for that particular issue for West Hollywood. Yeah. Have you checked with them to see what their position is?
Well, they say I can't get a straight answer, surprisingly, and I get shifted from here to there. And the drift is that, yes, these people can come back after almost 8 years at the original rental rate of like $500-600 a month for a 2-bedroom, 2-bath apartment.
Yeah, I would probably really want to go and check the statute for West Hollywood. I think with that time period, they must have something in their statute that says that the tenants can't come back in the normal course of business. And I do know the statute for Los Angeles, they do have the right to come back, but there is a certain period of time which is limited to 2 years. After 2 years, they don't have the right to come back. But I'm not sure what the specifics are in West Hollywood, even though I own property in West Hollywood. I'm not sure about that. So I would definitely, I wouldn't take the word of somebody at the city of West Hollywood. I'd want to actually check their West Hollywood ordinance and see what it states and see if there is a limitation. I can't imagine that it goes on that far. In any event, thank you for your question. I'm going to mute you and let's move on to, well, let's move on to Karen. So Karen, I'm going to ask you to unmute yourself. Karen from California, how are you?
I'm good. Thank you so much for taking my call. My sister and I inherited a rental property in Reseda, California. It's a family dwelling. It's an older home built in the 50s. And tenants have been living there for about 10 years at $1,700 a month. My parents were elderly when they moved them in. And so my sister and I was at first thinking about trying to do a sibling buyout to keep the tenants in, but I understand that I might have trouble like raising the rent, and because it is so low and the house does need a lot of work. I have been in discussions with the tenants since September. Very nice family. They obviously don't want to go. They're very distraught because, you know, they've built a life there in the home. And I'm just very confused about what I can do. I don't know if I want to do the buyout and try to keep them in, but then maybe having to raise their rent, and then house needs a lot of work, or if I just want to have them vacate so that my sister and I can like move on, and hopefully these tenants can move on too.
All right, Karen, let me slow you down a little bit. First of all,
Okay.
you have wonderful, wonderful options. You will have no problem accomplishing what you want, which is to make this a profitable property.
Okay.
Number one, this is a single family home with only one house on the lot, correct?
Correct.
Okay, so under the law, you're allowed to raise the rent to whatever you like. Whatever the market value is, you're allowed to raise that. If you go above 10%, that would be a 90-day notice. If it's 10% or less, it would be a 30-day notice. So you can dust off a change of terms of tenancy to raise the rent. It's on my website, and you can raise that rent to any level that you want. Now, you say that the house needs a lot of work. So there's another option for you. Since you're probably in my mind thinking that you're probably going to sell the property and you don't want to be a landlord. Is that probably the case?
It's how I'm feeling, just because I'm not used to having to deal with other people's, you know, lives, and, you know, and with all the new laws, and it's made me really kind of, you know, confused and a little bit scared. And on top of like grief of losing my folks, I don't know that I want to do it.
So then you have another wonderful option, which is that you can ask these tenants to move because you want to do major renovation. Major renovation is defined that work taking longer than 30 days to complete, which would render the premises uninhabitable for that period of time, and also requires that you get a building permit, like an electrical or a plumbing permit. So basically, if you were going to redo the bathroom and the kitchen, which you probably want to do anyway, after all this period of time, you're going to get those permits pulled first. You're going to get a contractor who's going to give you the quote scope of the work, showing how it will take longer than 30 days and will make it uninhabitable for that period of time. With those two documents, we can then apply to the city, which is some of the legal services we provide, and get them to approve our application process. Once they approve our application process, then we can serve your tenant with a 60-day notice to vacate. Now, here's the issue though. You have to pay relocation money to the tenants, but do not despair. The relocation is only 1 month's rent, $1,700 in your case. So on that basis, it might be better to do it that way. Or if you're saying, hey, you know what, I really don't have the money and I don't want to go through a construction or something like that, then your other alternative is just merely raise the rent. That might have the effect of making them move anyway. But if you are thinking of selling the place, you know you're going to have to do a little spruce up and a little renovation. So hopefully that answers your question, Karen.
Thank you. Thank you so much. And I can go through your office to do these
Either
forms.
one we can assist you with. We also can determine what the market value for your property is. We have our custom program that allows us to do so. Anyway, thank you very much.
Thank you.
Okay. Let's see. I am now going to call on a color. Let's call the color blue. I'm going to ask Blue to unmute yourself. Hello,
Hi.
Blue.
Hi, Blue. Thank you for taking my question. I have hopefully a simple one. For housing providers who own townhomes or condos that are RSO and in the city of Los Angeles, come February of 2024, is the amount you're allowed to raise it, is it 4% plus the extras, or is it market value with proper notice? I was confused about that.
If your property is a townhouse or a condo built prior to October 1st, 1978, your property is subject to the rent stabilization ordinance for the city of Los Angeles. You need to register those units, and also you need good cause to evict. But now let me tell you something incredibly wonderful for you. A townhouse or a condo is not subject to rent limitations. So even though you're part of the rent stabilization ordinance and you have to register your year every year, you are not subject to rent limitations. So don't talk to me about 4% coming up in February, which is for RSO properties that are not condos or townhouses. You have the right now, today, to raise that rent to whatever you like. If you're going to do it in the month of November, and I would probably get it out today, because it's today would actually be your last date, because November wouldn't count. So that would be December, January, February. So March 1, you want to leave 95 days, 5 days for mailing. So go to my website, dust off a change of terms of tenancy, race it over to your tenant, put one on his door and mail one, and raise that rent to whatever you want, because there is no limitations whatsoever. If you don't do it today, then it's just going to extend it till April 1st of next year if you go above 10%. How's that?
That's very good news. I really appreciate it, Dennis. Thank you for answering that.
No problem. Thank you. I'm going to now move on to see if we can get through all of these today. Wouldn't that be exciting? I'm going to go to Greg H. I'm going to ask you to unmute yourself, Mr. Greg H.
Hi, can you hear me?
I hear you fine. Well, maybe not.
My question has to do with the can you hear me?
Yes, I can. Go ahead.
Hello?
Yes, I hear you.
My question has to do with the pre-judgment claim of right of possession form. The situation is this: I have my process servers are trying to serve the tenants the summons and complaint, and the tenants are being evasive, and it seems like I might need to request to the court that if we can post and mail the summons and complaint. The issue is, I think there might be occupants in there that I don't know about, and so I wanted to serve that form. So my first question is, can that pre-judgment claim form be served by posting and mailing if I request to the court to be able to do that with the summons and complaint?
The answer is no. What Greg is talking about is that, and it's incredulous, only California, people can become, whether you like it or not, a defendant in your lawsuit. It's called a claim of right to possession, where they'll claim that, hey, I have a possessory right here and you didn't sue me, so I want to be sued too. This is insanity, ladies and gentlemen. But the reason is that they want to come into the lawsuit is that at the end of the lawsuit, if you don't have protection against these, quote, claimants, then they can delay the case at the end. And Greg, you're right. If you serve a lawsuit by an order to post, because the tenant's evading service, so you can go in and get a court order that allows you to serve your tenant by just posting it on the door. But that in no way allows you to serve these, quote, pre-judgment persons. So what you should do is, if nobody answers the lawsuit and you're just going to go by way of default, you've got to move on with your case. So you're going to have to do the order to post and take your chances against these pre-judgment claimants that might pop up their heads at the end of the case, right when you're trying to do a lockout, which is going to make you now go back to court and have a small hearing showing you that this claimant has nothing to do with you. The other way to do it would be if your tenant answers the lawsuit. Okay, so you served it by posting, and now he's made an appearance in the lawsuit. Your process server can go out there and now do a proper service on unknown occupants by just throwing the paperwork on the front door of the tenant as a sub-serve, because he's already made an appearance. So when somebody's already appeared in a lawsuit, you don't have to hand them any more papers. You can just drop it at their residence, which is what you would do, but that would be a substituted service on pre-judgment claimants. So assuming the tenant answers the lawsuit, even though you've gotten it by way of an order to post, you can take take care of the prejudgment claimants. Now that, ladies and gentlemen, was a lot of legal mumbo jumbo. So sorry that we got so technical on that one. But Greg, it is a good question. And I'm going to move on. Thank you for that. And let's see, let's move on to Nazilla. I'm going to ask you to unmute yourself. Nazilla.
Hi,
Hi.
how are you, Danny? Thank you so much for answering my questions. I have two questions. The apartment building under 1482, I want to know if they should be registered, as you just mentioned that some of the buildings should register in the city.
Okay, well, if your property is under subject to 1482, which for everybody out there is statewide rent control, you have no obligation to register it with anybody. There is no
Okay.
provisions for that under the state law.
The second question is, my tenant slipped and made a crack on new brand bathtub. So who is responsible for the repair? The contract is new, AOA new contract. It's new tenant.
Okay, so the question is, who is responsible for a crack in a bathtub when the bathtub is brand new? I don't know how a bathtub cracks, but here's the law. If the tenant negligently caused the damage, then the tenant is responsible. But that means that landlord, Nazilla, you're going to have to prove that he negligently cracked that tub. So unless you see some evidence that he took, like, I don't know, an anvil and threw it on the tub and caused it to crack, then unless you can prove it, then it is your responsibility. The same thing goes like with a broken window. Oh, my tenant, the window's broken, you have to pay for it. Well, the truth of the matter is that unless you can prove the tenant broke the window, well, your question would be, well, how would, of course he broke the window's broken. Well, you know, anybody can come by with a rock walking down the street and throw it through the window. So that's really where we are right now. So the issue is, in your situation, can you prove that the tenant damaged the tub by unusual wear and tear? If that's the case, then the tenant is responsible. Anyway, Nazilla, hopefully that answers
Yeah,
your question.
he just texted me that he slipped and he slipped.
Okay, but if
and
somebody
fell down.
slips in a bathtub, which, by the way, people slip in bathtubs, I can't imagine that a bathtub
And
would
he's
crack.
heavy.
I don't
It's
care how
heavy.
heavy it is. I mean, if we just let's think this out, you know,
Okay.
it's not like
Thank
you're
you.
taking a rock, you know, if he slipped and fell on his tushy, it's still going to be pretty soft. How does a bath crack? In my mind, based on the way you're telling me the story, that you had a defective bathtub. That's what I think. And I wouldn't hold the tenant responsible. Anyway, thank you very much for your
Thank you.
question. I am going to mute you. We are now moving on to my good friend, Jay-Z. I'm going to ask you to unmute yourself, Mr. Jay-Z.
Hi, thank you for taking my call. I'm just a little landlord with a tenant in my home.
Well, let me ask you this first, though. You say you're a little landlord. Are you saying you're short, or you don't have much?
Oh, no,
property?
I'm just, you know, compared to all these others that probably owned a lot of apartment buildings, I'm just.
So you're
renting out.
relatively tall then.
Yeah, I'm tall. Yeah.
Okay, good.
I just.
Okay, I always like to get the questions answered correctly.
Yeah. Yeah, so they've been here for 4.5 years, and I approached them about a month ago saying that I would really like to have my son and fiance move into the house. And I offered an incentive of $2,000 if they'd be willing to move out. And they were opposed of it then, but now they're in agreement. They found something that he wanted to rent, and they're in agreement. What kind of paperwork do I have to do? I don't want this to come back and bite me where I be sued or something like that. Maybe that they said, oh, well, he forced me out and everything like that. You know what I mean? So I want to do this legally, you know, with some kind of a document that I will give them $2,000 and they can move out, you know.
What city, please?
Winnetka, City of Los Angeles.
Now, are these people living in your house?
Yes,
Okay, so you're renting a room.
correct.
Okay, so the problem with what they call a cash for keys agreement, which is not going to be considered that you're pushing them out. I mean, if they sign an agreement, they sign an agreement. And unless they have, video footage of you taking a gun to their head while they're signing this agreement. The problem is in the city of Los Angeles, if a tenant says, okay, I'll move for $2,000, you sign the agreement, it's notarized, it's beautiful. The problem is that in the city of Los Angeles, there's only 12 reasons to evict. So even though they have your money, you might have paid them the money in advance. If they don't move on the date that they're supposed to move, you don't have the right to evict. We use a special contract that I devised many years ago called the Voluntary Vacate Agreement. And with our agreement, we indirectly can evict them if they don't get out. So what I would suggest that you do is give our office a call. We can prepare one of these agreements for you. It'll also shield you. We'll have a full release in that agreement, which is always good, so that they can't come back and say, 2 years ago I slipped on the property and now all of a sudden I'm starting to hurt. So
that's exactly what I'm going to do, because it'll give me peace of mind that I know I'm doing it the right way from a lawyer and everything, Thank you so much.
Thank you, Jay. Okay. I am now moving on in order to Karen Kahura. I hope I spelled your name or pronounced your name correctly. Karen, are you there?
Yes,
Hey
I am.
there, look at you.
Thank you for taking my call. I'm in a situation, I was on a previous Zoom, and I have a problem tenant who wants face-to-face, and you said to say no, and I did. And he's now refusing to put any requests in writing. And he actually wants to deduct from December's rent, but he won't put it in writing. He wants a face-to-face.
Well, what does he want to deduct for? What is he saying that you didn't do?
There was some there was an electrical issue. I've ended up just rewiring the whole unit. And so now he says he wants to deduct for utilities. And
Okay.
Displacement. I don't understand displacement because he never left. He never went anywhere.
Okay, well, first of all, you should be very happy if he deducts something from the December's rent. If that happens, you will not accept a partial payment. You'll only accept the full payment, and you're going to have wonderful grounds to evict. They have bastardized the doctrine of habitability, which started way back when, which said that a landlord has an obligation to take care of his property. And if he doesn't, then the tenant has the right to withhold rent. That's how this started. Well, all these laws are been totally bastardized by tenants, where every tenant's going to complain something was wrong with the premises and I have the right to withhold rent. But when you're talking about a warranty of habitability, it's very similar to a car warranty. When you buy a car, you get a warranty. Now, the warranty doesn't state that if anything goes wrong with the car, then I don't have to pay my car payment. It doesn't state that. It states that if something goes wrong with the car, bring it in. I'm not giving you a loaner car. You still have to pay your car payment, and I will fix that car in a reasonable period of time. Okay, a day, 2 days, whatever that is. A landlord has the same type of warranty. The landlord doesn't warrant that nothing will ever go wrong with his property. That's not what a landlord does. A landlord warrants that if something is wrong, that the landlord will reasonably fix it and to cause the least disruption to the tenant. But the tenant doesn't have the right to say, well, it happened and therefore I'm going to deduct something from the rent. And he certainly can't deduct for utilities. That would be, even if that would be never able to be deducted from the rent. He would have to sue you separately for that. So based on your previous call and this, I get the distinct impression you don't like this guy. So this is what you're going to do. You're going to keep your fingers crossed, and then come December, if you don't have your rent by December 1st, give me a call. We'll serve him with a 3-day notice, and you will not accept any rent for the month or any partial rent for the month of December.
Well, there's a secondary part to this. I don't know how I'm gonna get paid because I'm actually fearful for physically and emotionally. This guy has just been harassing me, and just today I overheard him saying that he was. I had an electrician come again because he's trying to make his case for deductions, right? So after the rewire, he said, "Oh no, that something's still wrong." So I had the electrician come today, but prior to the electrician showing up, I heard him on the porch, on the phone, saying, "Oh, well, I'm waiting for the electrician and for the B to come downstairs," because I live right upstairs from him. I'm
what
City
did
of
he mean by
LA,
that?
owner occupied. I'm
Well,
sorry.
What did he mean by that?
He said because he's ready to sock all of them in the face.
Okay.
Me plus
So
the
he said
electrician.
when your electrician comes, he's going to sock him in the face.
And me too, because he knows every time the electrician
Okay,
shows
well,
up, I show
tell
up.
him the next time you threaten me or my workers, I'm going to get a restraining order against you. So I suggest you shut up. That's what I would tell the guy. And if he truly has threatened you, and I don't know that that's much of a threat, but if he truly has threatened you, you certainly have the right to get a restraining order. And also, you should immediately commence an eviction come December unless you get your full payment of rent. What city is this property located in?
LA City, RSO.
Okay, so yeah, so you definitely want to get him out on that basis. So keep your fingers crossed that he doesn't pay you the rent. But again, if you're afraid, one more thing, if you're afraid to take legal action, which we hear from so many of our clients that, I'm fearful of this guy. Well, then that means he's going to be there forever and he's never going to pay you rent forever. So that's not going to happen. You're going to have to do something.
Right. Well, there's unauthorized occupant and a pet in there. So I was like, okay.
Well, now you've got 3
Now I got to
reasons.
wait till February.
No, that's not true, darling. In the city of Los Angeles, if they have unauthorized occupants or pets, we have the right to evict right this moment. We do tons of these cases.
Right now?
Move on. Right now, and we can also go on the rent, the dog, and the unauthorized persons. We are going to move on.
Okay.
Thank you very much, Karen. Yeah, let's see, Karen. Okay, let's move on to, let's move on to an iPhone. Mr. iPhone or Mrs. iPhone, would you please unmute yourself? Got to click the little button there. I'm asking to unmute. iPhone, are you still there? Ah, there you go. I think you're there. Hello, iPhone. Got to say hello. Says you're muted again. Try one more time. I'm asking you to unmute. Okay. Are you there? Last chance.
Sorry to text. Yes. Sorry. Can you hear me?
I can
Hello?
now, darling. I think we're going to have
Can you
technical...
hear me, Dennis?
I can, but if
Hello?
it continues, we're going to have to move on. So please give me your question.
Can you hear me?
Yes, darling. Last
Can you hear
time.
me?
Okay, I'm
Hi,
going to move on.
Dennis.
I'm so sorry,
Yes.
but we got to
Hi,
move.
can you hear me, Dennis?
Okay, I think we had enough. I'm so sorry. Let's move on to Marion Galbraith. I'm going to ask you to unmute. Thank you.
Okay, hi, Dennis.
Hello. I guess you have more technology ability than the last caller.
Well, that's probably not saying much for me anyway. I still don't have all that much, but Thank you so much for being here and answering these questions. And I have 4 units, 2 that are under the old rent control before 1978, and 2 that were built in the year 2000. And the last time I was on the Zoom call, you told me the rates that I can raise to, or I can raise as of February 1st, I can raise my RSO units by 7% and my newer units by 8.8%.
Right, but since that last telecast or Zoom meeting, the City Council of Los Angeles, in their ultimate wisdom, lowered it from 7% to 4%. That was about 10 days ago that they lowered it. I tweeted about that, and everybody should follow me on Twitter if you have a Twitter account, which is twitter.com/DennisBlock, no spaces, and you'll get the latest. But in any event, they did lower it to 4%. They were going to extend it for 6 months past February 1st. Now they lowered it to a whopping 4%. This is insanity. It's a true taking where we haven't had a rent increase in almost 4 years, and then they're giving us a whopping 4%. So with regard to your units built in 1990, that is still 8.8% under the statewide rent control, AB 1482. Under your RSO properties in the city of Los Angeles, it's going to be a whopping 4%. I recommend that you serve your notice around December 15th to take effect as of February 1st.
Okay, but you're saying the 7% is gone. I have to, as of 10 days ago, they just up and did this.
Unless you want to march with me down to City Hall.
Okay, and I still can't do it before February 1st. Okay, so I have to scratch that out, put 4%. It seems like the laws have changed where I need a bunch of different forms now. And I just want to make sure that before I do these rent increases on all 4 units, that I have the right paperwork and the right things hanging on the walls there.
Okay, for the city of Los Angeles, for your property that is built in the year 1990, not subject to RSO, there's this eviction tenant protection posting that needs to go on your property. It's a 2-page colored form that has to go on every residential unit in the city of Los Angeles that is offered for rent. I don't care if it's a single family home or a 50-unit apartment building, that has to be posted in a conspicuous spot, including even a condo posted by the mailboxes in the lobby area, assuming there is a lobby area. Now, if your property is RSO, in addition to those first 2 forms, there's another one, which is a notice that this property is subject to RSO. These forms are all on my website. Those all 3 pages have to be posted if your property is RSO. That 2-page Tenant Protection Act has to be posted if it's not under RSO.
Okay, and then the actual, is there an actual form that you use to, or can you just send a letter asking, saying that your rent's going to be 4%, or is there a specific form?
No, I have a form on my website, which I recommend that you use. It's a rent increase form. If you go to my website, evict123.com, go to the landlord free form section and scroll on down, and you'll find it. It's actually fillable, where you can fill it in right on the screen, print it out, and go serve it on your tenants. But remember, if you do serve it, you can serve it by mail, but then you have to add in another 5 days. So a 30-day notice would be a 35-day notice unless you specifically hand it to the tenant. Marion, thank you very much. I am going to mute you. Appreciate your coming on. Let's move on to Diane Delaney. I'm going to ask you to unmute. Hello, Diane.
Hello, Dennis. How are you?
Good. You're looking very spry there.
Those are my little kitty cats. I hope you're not anti-cat.
No, I'm anti-everybody.
Okay, that's good.
I don't discriminate.
I like that about you. Dennis, I have a real specific problem. I have a single family residence in city of LA, and I got the unfortunate notice that my tenant got killed in a motorcycle accident in the middle of the month, and he doesn't really have relatives, but now I'm finding out he has a son out of the area that he was kind of disengaged from. But I've talked to them, these distant relatives, and everybody seems very nice. But I'm finding out that a friend of my tenant has a key to the property, and he's looking after the property and talking to the legal heirs. But I don't know what to do. I talked to this friend and I said, oh, well, I said, I'm going to go by and secure the property because that's my legal duty. And he says, oh, well, you better follow California law. He got very upset that I was going to go buy the
Hey,
property.
let's go follow California law.
Okay.
The rent hasn't been paid for the last time rent was paid was, I'm sure, more than 30 days ago.
It was paid November 1st.
Okay. So on December 1st, go change that locks. Unless somebody's living in there, you can't do anything with that.
Okay.
So,
okay. And then, so what do I do? So I got stuck one time with a similar situation where on these, the notices on the, I'm sure the distant heirs are going to want to come and take, the 3 things of value and then leave me with all of the trash,
well,
right?
and that's what's going to happen. You're going to be left with the trash. As long as it's a close relative, have them sign a statement that they're entitled to it and then give it to them. But again, on December 1, go change those locks immediately.
Okay. Okay, good.
Thank you. Is there another quick question? Yeah.
One more question is, okay, so I've just started doing the 90-day notices to some tenants that have very, very low rent. But I wanted to know, I'm on the matter of renters insurance and that sort of thing. I can give them a separate 30-day notice to ensure that they are having those type of things apart from.
Absolutely. And that change of terms dealing with insurance is on my website.
Right. I saw that. Thank you.
Okay, Diane, we're going to move on because we're going to try to get through as many as we possibly can. Let's move now to Kay Benz. I'm going to ask you to unmute yourself. Hello, Kay. Yes. Hey, Kay, how are you?
Hi, thank you for taking my call. I've been told by someone that landlords in the county can apply to bring their low rents up to market value. Is that true?
What kind of a property? Is this an apartment house?
Yes,
In what city?
there's in the county. I
Are
guess
you talking
Inglewood.
about an unincorporated area of LA County?
Yes, yes.
Okay, so if you have multiple units, then like a duplex or something bigger, you're subject to the county law. And right now it's 3%. There is no such thing as a unlimited or large rent increases for county property. You're subject to their rent statute.
So no one can bring their rents up to market value at this time, not in the county.
No, in fact, I'm sure that the person who told you that cleans pools for a living and probably does an excellent job.
Okay, I know if they can't do it, the city can't do it. So thank you.
All right, darling. Okay, let's move on. I'm going to go to Abe. I'm going to ask you to unmute yourself.
Can you hear me?
I can.
Oh, how you doing, Dennis?
I am fine, thank you.
I've worked with you for years. You're the best there is in Los Angeles. I purchased a very large piece of property in Koreatown through the tax sale last month, and I went over and discovered the guy's been living on the vacant land for 22 years, and there's trash 4 feet tall. So I went over to talk to him, and he said he has sweat equity, and I can't evict him because I don't have a deed to the property. And you know how the county is; they're going to take 3-4 months. But I happen to tag the old owner. He lives in Israel. He said he's willing to fly in if I pay him to fly into LA one day, and I can use his name to evict him. And then he can give me a power of attorney to continue it on. Is that going to be legal for me to do that?
Right now, you're not the owner of the property because you're waiting for the tax sale to become legalized. And you said he's on vacant land?
Yes, there was a castle there, and the city tore it down, and they billed him $547,000 on his property tax bill. and he wasn't able to pay for it for 22
So
years.
he's living in a tent? Where is he living?
Yes, on the tent. He got a tent on
Right.
there.
I
And the
wouldn't-
lot's 10,000 square feet, full of trash.
Okay, I wouldn't waste my time flying some guy out from Israel, though he probably wants to get out of
He's the
Israel.
owner. He was the owner of the property.
I understand.
Okay.
I understand. I wouldn't waste your time at this point in time. I would wait till you become the true owner of the property, and then we will be able to evict him. I don't really care about something called sweat equity. I don't know where he gets that term, but obviously he wasn't putting much sweat into it because the place looks like a slum. So
Yeah,
tell
it
him
is.
he should have put some sweat into it. But as it stands right now, I would wait to become the true owner of the property. You never know what's going to happen on these things. And then once you are the owner of the property, then call us up and we'll be able to evict.
The owner says he's willing to sign the eviction right now and get him out.
Yeah, I don't know how that's going to work because right now it's already in a tax sale, so he's kind of lost it. You're in the waiting period. I don't know that he has the right to bring it forth right now. I would just wait till you become the owner.
3 more months, right?
You got it, darling.
Oh, boy.
All right, Abe.
Thank you, Dennis.
let's
All
see,
right.
We're
Thank
getting
you.
pretty close. I'm going to mute you. And let me lower your hand. And now we're going to move to Diane A. I'm going to ask you to unmute yourself, young lady. Hi there.
Hi, Dennis. Thank you so much. I have a tenant in the city of LA. It's a condo. He has what they call qualified disabilities. Lately, his rent checks have come from AIDS Project LA, and his rent is currently 54 days late. He does have 2 attorneys that are from the LA Bar Association. He has night terrors. He's had this since he's been there, and I just learned about them in the last 8 months. The tenant below him has just moved out. He took recordings. He went to the police department. They wouldn't take a report because of the noise. There's a tenant that lives beside him, and nobody was willing to speak up. The tenant
but my love, the only reason you have a tenant, and this is going to come as a shock to you, is to get rent. If you're not getting your rent, all this other stuff, he's got 2 attorneys, he's got all these disabilities, you're not getting your rent. So you need to start an eviction based on non-payment of rent. It's as simple as that. There's nothing that says you can't.
All right. Well, I will definitely do that. I'll send him a 3-day notice, or I'll look into that. I am just saying that neighbor, the owner below, his tenant moved out and he started soundproofing the roof. And I've already
Okay, so the guy's a mess and very because nuisance behavior. So what difference as to the reason why you evict? It's easier to evict on non-payment of rent. So let's evict them on non-payment of rent. That does 2 things for you. Let's go over those 2 things. Number 1, you now have created a quiet environment. And number 2, you're going to get somebody in there who's going to pay you the rent. So you're going, and I see this all the time, you're going on a merry-go-round and looking at all these unrelated issues. The first issue is, why do you have this person in your property? What was the motivating factor to put him in?
Well, of course, because the rent, but he gets rent
No
from
buts. No.
LA. He keeps on telling me the rent's coming in any day.
It doesn't matter. So okay, great. We'll serve him with a 3-day notice. And if he pays within the 3 days, then we'll evict him based on the nuisance issue. Okay, which
on
is
the
nuisance issue for making a bunch of noise and going crazy.
Nobody's willing to step forward to say he's a nuisance. And people have moved out. I mean, how am I going to get them on nuisance when there are no witnesses that are going to stand up and say, look?
I have many clients that act like you act. And that is that instead of doing what you need to do, you keep talking about roadblock after roadblock after roadblock. So the reality is, all these things you're saying are true. Do nothing. Let them live there forever for free. And don't worry about the fact that other tenants are complaining about him and making their lives miserable. Well, so what you need to do is really simple. Do nothing. Or do what you're supposed to do and start an eviction case. It's not the worst thing in the world. In fact, I kind of enjoy doing them. And with that, Diane, I am going to say goodbye to you. And just think about what I'm saying. Okay, let's move on to, where are we? Oh, we're at the 4 o'clock hour. Boy, this went fast. I'm going to go to College Aid Works as the last one because I went to college once. So I'm going to ask you to unmute. There you
I'm
go.
unmuted.
Oh
Thank
my
you.
God. You're our
She
last
did it.
caller.
I have a degree. Thanks. I'm able to unmute a Zoom call. Okay, so we filed an unlawful retainer for a tenant of mine in LA, RSO. It hasn't been served, and this person is extremely crafty, as probably a lot are. He has a busted mailbox, and he's been a tenant since 2017, and last year he decided it wasn't a problem. And then it started getting broken into, and he decided he would rather have a mailbox in Long Beach away from LA. I'm worried he's going to try to use this as a reason to not be evicted for non-payment of rent.
Well, during an unlawful detainer, there are things that need to be mailed to your tenant. And the first thing that comes to mind when I'm listening to your story is you said he has a busted mailbox. I have a crazy notion. Fix it. Why?
No, right, to replace it, right.
Okay, so fix it. Find
No,
that
I will,
mailbox.
but I'm asking because all of this is already in process.
Well, but whatever, fix the mailbox. And if you do have to mail something, then mail it to both places. Mail it to his other address that he has in Long Beach. So he could be crafty, but he's probably going to get evicted. Okay.
Okay, but this is in motion. That's why I'm asking.
Well, in motion, fix the mailbox yesterday. In
All
motion.
right.
And in motion, whatever you need to do in the future, send it to both places. Anyway,
Okay.
I am going to say
Thank you.
no problem. I'm going to say goodbye to everybody. I hope everybody has a wonderful Thanksgiving weekend. I really, really, really enjoy doing this. I'm going to be obviously editing this. So if you ever want to see yourself after this, just go back to my website, evict123.com, and you'll get to see this telecast edited. And I do appreciate all the people who call in. And I'll try to pick on the rest who we didn't see today. But thank you so much. I appreciate you guys.